Hi, Robin here. Going to look at computer-related legislation as part of the OCR A-Level Computer Science. This is the Data Protection Act. The Data Protection Act ultimately is here to protect us due to the benefits for businesses or other organisations of having data. Data in many ways is the modern gold. It's the thing that is most powerful. If you know things about your audience, your customer, where they are, how to contact them, the things that they're interested in potentially buying, you can therefore make incredible amounts of money from data, and therefore data itself has incredible value. Again, data is, because of computers, able to be stored in massive quantities and also to be sent around the world within seconds, and therefore that creates a vulnerability to that data. So we have something that's of great value but is also incredibly vulnerable and easy to spread if you didn't want your data to be shared in some way. So the Data Protection Act exists to protect us from this. What's important when we consider data is to be aware there's two main different types of data. There's personal data and sensitive data. Personal data is things like your name and address, which, yes, if people were to know that would become potentially an issue. It's your privacy, it's your right to that privacy of that data. But it's more going to be impacting on things of like how often you're bombarded by advertising, or I suppose there's a safety risk element to that data as well. Whereas the sensitive data, though, is much more about you as a person, the things you believe in, your sort of aspects about you, qualities that you have, which could be used against you or could be used if somebody had an intent to divide or to separate out people based on these things. So simple thing would be your political opinion. Do you lean towards one side or the other, and therefore what does that say about you, or how could you be judged by that view or opinion that you have? And ultimately want to protect that right for people to have things like political opinions, and therefore the Data Protection Act is there to help support that. Okay, there are 8 principles to the Data Protection Act, as we can see here. I'm going to go briefly through each one. Our first one is that personal data should be processed fairly and lawfully. In other words, you should be only taking the data that you legitimately need for the circumstance that you're in. So an educational institution would want to know things like your GCSE results. Doctors would want to know your medical information. That data is what they need to carry out their particular circumstances, but they certainly shouldn't be asking for anything more than that if it's not relevant to the situation and the things that they need. And therefore, again, the way that they handle that data should be appropriate. Again, that data should only be obtained for the specific purpose that it's needed for, and again, be compatible with that purpose. So you can see we're building on this concept that if you're giving data to your local GP, that GP certainly shouldn't be passing that information on to somebody else, such as a business, who can then try and sell to you in some way. That data should only be relevant and not excessive. So again, if you're giving, say, medical information to your, say, college that's relevant to your education, such as that you have a certain learning need, or that's something that a medical aspect that might impact on the way a lesson happens, or would be a concern that, say, a teacher would need to know about in case, say, there was a medical emergency that would affect you in some way, well, that's legitimate. That's something that needs to be known. Whereas the fact that you had an operation back in, say, when you were 12 or something is irrelevant, isn't it? If it has no bearing on your education and no relevance to that. Again, that data should be always accurate and kept up to date. So there is an onus on the company to remove any non-up-to-date data, to be checking with you. This is something that businesses will often do from time to time, is contact you and ask, can we still have your data? Is this accurate data? And then again, you've got then the right to sort of request that to be changed or updated. Again, personal data should be processed only for the purposes that it's needed, and therefore shouldn't be kept for longer than, again, is needed. So, for example, your college will keep some of your data for a period of time afterwards, because of they may need to contact you about, say, when your certificates are ready, or if there's some form of celebration of kind of you receiving your results. But apart from that, they don't then need your data anymore, and most of that should be removed relatively quickly once you've left. If you are going in and buying a product, obviously that company needs your bank details to actually buy the product, but then if they hold on to those bank details for a lot longer, it only implies they're going to be misusing them, doesn't it, really, and therefore shouldn't be doing. The data should be processed in accordance to the rights of the data subject. So what we mean by that is we have various rights, as you can see here, the access to a copy of the information that's held. You should be able to object to certain data, object to decisions being made by that data. So what I mean by that is by automated aspects to that data. And again, you can't therefore have certain data held against you or misused against you. The very famous example of, say, somebody who's involved in trade union activities being then banned from an industry just because of that union activity, and that's illegal. That's not something that's allowed. You shouldn't be able to block somebody for that belief that they have or that activity that they have. They should be free to work and not without constraint. We have appropriate technical organisational measures should be taken against unauthorised or unlawful processing of data. So therefore, in other words, to simplify that, the company must put in everything they can to protect that data, such as firewalls, their cybersecurity procedures, making sure that data is encrypted, etc. And then the final one of these is that personal data shall not be transferred to a country or territory outside of the EU. So obviously with Brexit, this has meant that Britain technically had to change these rules. Well, a lot of these rules have been adapted over from the EU rule anyway. They have been updated since the Data Protection Act in 1998. There's the GDPR update, which again has this within it. But because the OCR A-Level spec is relatively old, 2015 when it came out, it therefore means that we do sort of still include the Data Protection Act as it is. There are some exemptions from the Data Protection Act. For example, if you are sort of trying to investigate into somebody, there will be data that you need to get hold of, for example, in the interest of, say, national security, and those things need to obviously be dealt with in an appropriate way as and when they're used by whichever particular organisation. Again, somebody like HMRC working out your tax should be able to access certain data to check that you aren't avoiding tax. Okay, well, thank you for watching. I hope you found that useful. Please do like and subscribe, help me to help others, and I'll hopefully see you again.